So welcome to the first CIPL seminar of Easter term. I'm John Lidico, a Senior Research Fellow in CIPL, the Center for Intellectual Property and Information Law, as well as the Center for Law, Medicine and Life Sciences. We're privileged to have Professor Rochelle Dreyfuss presenting on investor disputes and how these could affect the implementation of, amongst other things, a patent waiver in TRIPS for COVID vaccines and other medicines. Rochelle is one of the stars of the IP world. She brings a critical perspective to many facets of IP, especially in patents in the biosciences where she is trained as a chemist, but also, as we'll hear tonight, related international law issues such as trade disputes. A few items not mentioned in her bio tonight include that she served as an expert for the report of the UN Special Rapporteur on cultural rights regarding patent policy and the right to science and culture, and she served on 3 National Academy of Sciences committees, including one on intellectual property rights and the knowledge-based economy. Rochelle is no stranger to Cambridge. She was the Goodhart Professor here in the academic year 2019-2020. The Goodhart Professor position comes with the Goodhart Lodge, which the Goodhart Professor has access to for the entire year. Now, to many of you, this probably sounds quite attractive. I know I'd like to live somewhere that is commonly known as a lodge. But little do you know that when Rochelle took up residence, a few things were in need of repair, as it hadn't been occupied for a while. And when I say a few things, I mean a great number. Consequently, Rochelle, the Goodhart Professor, also played handy person, or at least project manager, of repairs to the Goodhart Lodge. I'd now like to begin, but just one more note. We'll have plenty of time for questions at the end. So as we're going, please write your questions or comments in the Q&A. Other than that, Rochelle, the floor, or as it were, the screen is yours.
Thank you, John, for inviting me and reuniting me with all of you guys in Cambridge. I miss being there very much, despite all the problems with the lodge. And I hope that eventually I'll be able to come back and see what May is like, because I was locked up in the lodge during May because that was during the pandemic. Anyway, I'll start with some history on this project. Some of this everybody probably knows, but just to be on the same page. So in the before times, I was asked to write a chapter for the 2019 Yearbook on Investment Law on the impact of international investment agreements, IIAs, on IP-related state action. In case there's anyone who doesn't know, IIAs encourage investment in foreign countries by protecting investors, loosely put, expectations, specifically the expectation of not being discriminated against by the host country, and that their assets won't be directly or indirectly expropriated, that is subject to a regulatory taking, and that they'll receive fair and equitable treatment. Traditionally, that also allows investors to bring arbitration proceedings, ISDS claims, investor state dispute settlement claims, against host countries that violate those obligations. So IP is generally considered a protected asset, but that year there hadn't been any IP cases that went to a final award. That's why my article was called The Case of the Dog That Didn't Bark. But there had been 2 big cases in the past. I'll elaborate on them shortly. But as I argued in the piece, both illuminated the risk that IIAs would interfere with state regulatory authority to protect health. And I suggested that governments needed to better safeguard their powers in the future. And I also used the piece partly to survey the IIAs that had been concluded in 2019 to see what negotiators had actually done. The invitation to contribute to the 2020 yearbook came after the pandemic had started, after states had begun to realize that they'd want lots of material for their citizens that was either already protected by IP or once developed would be subject to intellectual property rights, things like diagnostics, treatments, data, vaccines. Now, there were a lot of voluntary efforts to ensure development and equitable distribution, IP pledges, voluntary transfers of technical information and finished products, promises to sell at prices close to cost, The World Health Organization, with the help of various organizations, also established COVAX to facilitate research and ensure equitable access, particularly to vaccines. But none of that was enough. And much of the world, especially in the South, as I'm sure you know, remains unvaccinated. There have been outbreaks and the emergence of worrying variants and many deaths. And the fear that that would happen had led states to engage in various forms of self-help right from the beginning of the pandemic, actions to ensure that they would get supply at reasonable prices. And we'll look at those in a minute. Of course, that raised questions about compatibility with these IIAs, and also questions about compatibility with the TRIPS agreement. To deal with the latter, the Council for TRIPS was asked to waive obligations regarding COVID-related IP for a period of time, initially 5 years. So that's the history, and it's led to quite a few interesting questions. I initially took it as an opportunity to conduct a thought experiment, a kind of stress test to see whether new and old IIAs gave governments enough flexibility to deal with an actual pandemic. The history also raised interesting questions about the relationship between TRIPS and IIAs. Is compliance with the TRIPS agreement a defense to an ISDS action? How should investment tribunals think about what the WTO has done? Should they accept WTO panel or appellate body interpretations of state obligations? Should a waiver of TRIPS also waive IIA obligations? More generally, does TRIPS furnish a measure of the protectable expectations of investors? Or even more generally, what's the relationship among international agreements and institutions that do things that relate to health, such as WIPO or the WHO? Now, after I wrote the 220 paper, Henning, along with Federica Padot, addressed the question of the effect of the TRIPS waiver on IIAs and also on other IP agreements in a report that they wrote for the South Center. They adopted a systemic integrative approach to disparate international agreements, very much in line with a report I admire by Marty Koskamieni on how to deal with fragmentation of international law. In their conclusion, and I'm sure it's oversimplified, and I hope Henning is there, maybe we can talk about it later, but their conclusion is that as a subsequent agreement among the members of the WTO, the waiver should be viewed as also waiving obligations under other agreements to which those members are parties. So that would include IIAs. Now, unfortunately, the waiver has not been enacted. Why not is, of course, a whole other story. Maybe it's because IP rights aren't the holdup. Maybe it's the lack of raw materials that are preventing there being enough vaccines. Maybe it's the lack of manufacturing know-how, and that remains undisclosed. Maybe people are worried that a waiver now would undermine incentives to develop what's needed in the future. Or maybe it's because people see a waiver as unnecessary given the flexibilities that are already in the TRIPS agreement. But whatever the reason, we don't have a waiver, and that leaves states on their own. And so my paper largely addresses what the impact of IIAs would be on those self-help measures in the absence of a waiver. Do IIAs adequately safeguard authority to protect the health of a government's citizens? We can talk about the waiver and Henning's report in the Q&A. I think that would be interesting, but on with mine. So as I mentioned, there have been only a few disputes directly challenging state action affecting IP, but there were these two. One was a case brought by Philip Morris against Uruguay, challenging Uruguay's initiatives to stop smoking. Uruguay largely followed the WHO's Framework Convention on Tobacco Control, and it mandated that tobacco products be what people call plain packaged, although if you've seen, well, you have them in the UK, they're not really plain packages, they're really pictures of cancer victims that are really quite remarkably disgusting. But the trademarks are in really tiny letters. And Uruguay did something else, which is that it allowed companies to sell only one variant. So they could sell regular cigarettes, or they could sell menthol cigarettes, but they couldn't sell both. Anyway, the claim was that the measures interfered with trademark assets. The other dispute was a challenge brought by Eli Lilly against Canada for adopting a patent law doctrine, the promise utility doctrine, which made it harder to acquire patent protection. And in particular, it curbed the ability of pharmaceutical companies to engage in evergreening, getting consecutive patents on essentially the same formulation on the basis of a new promised utility or a promised new utility. And the claim there was that it interfered with patent assets. Now, in both cases, the states, Canada and Uruguay, won. Nonetheless, both cases chilled states' exercise of their regulatory authority. For one thing, it's quite risky to interfere with foreign investors' IP. The demands are for a great deal of money. You can see in both of these cases. And the litigation is also extremely costly. States can recoup at least some of the costs of the litigation, but that's of course only if they win and when they win. But these disputes can take a long time to resolve, so the outlay can be quite high. And in fact, we know that states have been deterred by the prospect of ISDS. In several cases, Philip Morris simply threatened an incalculable amount of international trade litigation, and countries backed away from plain packaging of cigarettes and tobacco. Indeed, many states, including some pretty wealthy ones, only enacted tobacco legislation after Uruguay won that case. And Uruguay partly did it because Michael Bloomberg, the ex-mayor of New York, very rich man, provided the funding for it. There are also examples of this backing off dynamic in the patent sector as well. Now, of course, if these cases could be easily dismissed, that problem might abate. But investment law as it applies to IP is unclear, and these two tribunals were not much help in clarifying it. They left many issues open. First, how to decide when a regulatory expropriation has actually occurred. No clear rule, you go facts by facts in individual cases. And in particular, it wasn't clear whether a tribunal should focus exclusively on the assets that are the subject of the regulatory taking, or whether they should think about those assets and their value in the context of a holder's entire portfolio of IP rights, or a higher portfolio of assets within the country. That wasn't clear. The Uruguay tribunal said that when an action is an exercise of a state's police power, it can't be considered expropriatory. So that's kind of good. However, there is a disagreement in international law on the question whether protecting health is an exercise of police power. There's no stare decisis to arbitration decisions. Another question is what must be shown to justify its use. On that, Uruguay was given considerable deference and was allowed to rely on the WHO's Tobacco Convention. However, the tribunal suggested that that reliance on the Framework Convention of the WTO was applicable only because Uruguay had limited resources, leaving open the question what other countries would have to prove. Similarly, there are questions about fair and equitable treatment guarantee. So it certainly includes protection against the denial of justice, but what constitutes a denial of justice is unclear. Is it about corruption and lack of due process, like failure to get notice, or is there other actionable conduct? And most important, Lilly had claimed that it had a legitimate protectable expectation about the contours of Canada's utility requirement, and that it was denied fair and equitable treatment because the Canadian Supreme Court changed the law to that promise utility doctrine and did so dramatically. Now, whether that's the legal standard, an issue the tribunal left open, is particularly important because, as I said, the pandemic has led states to make or consider making many dramatic changes. They made it easier to award compulsory licenses. Many countries had opted out of Article 31 bis of the TRIPS agreement, which allows one country to make product under a compulsory license for the benefit of another product. Many countries had opted out in order to get the countries that didn't like Article 31 bis to agree, but some of the opt-outs were thinking about opting back in to make sure that they could get enough materials to deal with the pandemic. Some imposed price caps on COVID-related pharmaceuticals. Some may have changed their exhaustion regimes so that it could import from countries where supplies are cheaper and do so even without the consent of the patent holder. Some changes could have also been made through judicial interpretation rather than legislation. So expanded views on what constitutes experimental use or crown use. I think when I was there during the pandemic, one of you gave a paper on crown use and expanding it. In the US, changes in rules on inventorship and ownership. And that was because US government scientists have been heavily involved in inventing COVID-related materials, and the United States doesn't usually claim inventorship and therefore doesn't own the patent. Changes in the availability of injunctive relief so that local manufacturers that were making materials, even without the right holder's authorization, could continue to do so for the period of the pandemic. So the paper looks at these COVID-related efforts and asks how easy it would be to justify them to an ISDS tribunal. And in particular, what's the effect of the WHO's declaration of a public health emergency of international concern? Now, of course, when I wrote this, it was unlikely that ISDS challenges would be asserted. The public reaction would be just horrible. But COVID-related claims have started to surface. There's at least one in ISDS right now, and there are several claims going on in US courts about unauthorized use of patented materials. However, the effects of the pandemic are not likely to disappear quickly, perhaps not even in the 5 years contemplated by the waiver, because states are going to have to deal with declining immunity, new variants, those not previously vaccinated, and for treatments, long COVID. So one question is whether states could easily obtain a dismissal of a challenge to one of these actions. In other words, might states be able to kind of short circuit ISDS before the cost just exploded in the way that we saw in the Canada and Uruguay cases? That might be possible because IIAs almost always have security exceptions in them. So this is the security exception in the new US-Mexico-Canada agreement. However, some of these exceptions are potentially of very limited value. So not every IIA has a board exception like this one. So the predecessor to the USMCA, NAFTA, its security exception reads like it's kind of limited to military type problems. Also, they're not self-judging. To be sure, the WHO's declaration of a public health emergency might help, but given the Uruguay tribunal's limited reliance on the WHO's tobacco convention, I would expect that a respondent state would at the very least be required to prove a local problem severe enough to be a danger to security. There's also a temporal issue. The WHO will eventually end the emergency. And once that happens, continued use of patented materials may become harder to justify on the basis of a security exception. The result is that these disputes may not be easy to dismiss, and states may well be required to go to the merits very expensively and prove that there was not discrimination, expropriation, or a denial of fair and equitable treatment. So how would that go? So let's start with expropriation. I'm going to deal with discrimination along the way. So many of these measures will reduce the value of patents in COVID-related material, for example, price caps. Now, of course, as I said, there's this question of, do you look only at the assets that are the subject of the regulatory taking, or do you look at the entire portfolio of the patent holder? Those mRNA platforms are going to be valuable for a long time going forward. And so what's taken right now might in the end not be very much. But putting that to one side, if they do decide to look at the assets that are the subject of one of these self-help measures, what would happen? So a state could invoke its police powers As we saw, the Uruguay tribunal understood actions pursuant to police powers to be outside the ambit of protection. That part, I think, is agreed. But remember, whether actions to protect health are considered an exercise of police powers, that's contested. And the next tribunal might not agree with the Uruguay tribunal. And even if it is regarded as an exercise of police powers, the state may still be required to prove a bona fide public purpose, proportionality, and that the action is non-discriminatory. So the public purpose requirement probably would pass muster, with maybe the temporal caveat: what happens when the emergency declaration is withdrawn, or there's already herd immunity, maybe it's not such a public purpose anymore. But the other requirements are also tricky. So US law doesn't actually have kind of this notion of proportionality expressly in the law, so we don't know what it means at all. Of course, we see it in EU law, but you just take a quick look at any EU case on proportionality, and you see that it's not so easy. I just read Tuesday's ECJ decision on the Digital Single Market Directive and Article 17, and I certainly don't quite get what it means there. Non-discrimination could also be a problem. The action will only affect pharmaceutical companies, and they're predominantly from the US, the UK, and the EU, so there is an element of discrimination there. Indeed, in the Canada dispute, Lilly made precisely that argument. It lost, but only because it couldn't make out a factual case. Here, the facts are a little more clear-cut, so a tribunal would be forced to contend with the legal question whether IIAs protect against only de jure discrimination, let's screw the United States, UK, and the EU, or de facto discrimination like this, let's take it to pharmaceutical companies, gee, they happen to come from the US, the UK, and the EU. So if a state can't convince a tribunal that it is acting under its police powers, then it will have to argue something else. And here's where the relationship with TRIPS is particularly fraught. So consider compulsory licenses. Some IIAs, and here's chorus, have a provision exempting compulsory licenses from the ambit of expropriation when they meet the requirements of the TRIPS agreement. But who decides? There are many conditions in the compulsory license provision in TRIPS, Article 31. Would a tribunal defer to a WTO interpretation of those conditions or decide the interpretive questions for itself? As Henning has pointed out in some other writing, the burden of proving things as you move from the WTO to ISDS sometimes shifts. And so if you're in equipoise, a different person might win those cases. Other conditions with Article 31 can be ignored in the case of a national emergency or extreme urgency, but again, is that provision self-judging? And what if the conditions for issuing a compulsory license are waived? So notwithstanding Henning and Federica's cogent analysis, it isn't entirely clear that an action taken pursuant to a waiver is the same as an action taken in accordance with the TRIPS agreement. Besides, the proposed waiver would only apply to COVID-related inventions. And then we have again the question, who decides which inventions are sufficiently related? Who bears the burden of proof? What of other actions that a state might take that decreases patent value? Is consistency with TRIPS a defense in those cases? The IIA don't say. And also TRIPS considers, leaves considerable room, I should say, for regulatory autonomy. For example, it says nothing about price caps or ownership. Per Article 6, states can adopt any rule on exhaustion that they like, so long as it's non-discriminatory. Under the Canada pharmaceutical case, Article 30 permits some degree of experimentation. Under the China enforcement WTO case, courts can decline to use their authority to issue injunctions. Furthermore, there's the Doha Ministerial Declaration and the Declaration specifically on public health. Both of them emphasize state autonomy with respect to health and focused attention on the agreement's objectives, which include balancing public and private interests. So the question there is whether ISDS tribunals would recognize the regulatory space that was specifically left open in the TRIPS agreement, or would it disappear in the context of IIAs? It may well be that despite these flexibilities in TRIPS, and ISDS states will nonetheless be required to show a public purpose, non-discrimination, and the adequacy of compensation. So public purpose should be relatively easy, as we said, as non-discrimination a little bit harder. And then there's also this question of compensation and how it should be measured. Would it be measured the same way here as in the TRIPS agreement, or a different measure? When measuring compensation, would a tribunal consider only monetary compensation, or might it consider other benefits, such as, if you got my vaccine for free, that burnishes my reputation and builds goodwill. Those have value as well. Israel's agreement with Pfizer includes exclusive rights over data about the patients that were vaccinated with a Pfizer vaccine. Would that be considered part of compensation? How would it be evaluated? So that's a regulatory taking. And then there's the issue of fair and equitable treatment. So some measures, such as compulsory licensing provisions instituted by several countries, may be vulnerable because they were adopted right at the beginning of the pandemic, before there was really any clarity as to what the situation might be. In addition, fair and equitable treatment, FET, requires a showing that the action is not arbitrary. The proliferation of vaccines and diagnostics and treatments is, of course, a blessing, but a state may have trouble justifying its choice among all of the vaccines, et cetera, that are available of a particular claimant's product. However, the real threat here is Lilly's claim that dramatic changes in law amount to a fair and equitable treatment violation. To be sure, Susie Frankel and I and others, including Hemning, have forcefully argued that the Lilly Tribunal did not agree that investors enjoy this protection. Rather, the argument faltered on its facts. The tribunal thought that Canada succeeded in proving that the change was incremental rather than dramatic, or that Eli Lilly didn't succeed in proving otherwise. Still, this idea about dramatic change has lingered. Of course, it's easy to understand why investors would value predictability, but it's hard to believe that a sophisticated investor would expect it. Social needs change, technologies change, the strategies of right holders change. States have to be in a position to respond to those changes, to reallocate profits among industrial players, first and later generations of innovators or proprietary and generic firms, and a social needs change to continually readjust the balance between the interests of the public in access and proprietary interests and profits. TRIPS was drafted in part to give states these types of flexibilities. They were emphasized in the Doha Declaration. That IIAs could expose TRIPS compliant measures to more scrutiny is somewhat worrying. And it's especially worrying that states can be bullied by the high risks and costs associated with ISDS to not take all of the actions that their citizens might need. And indeed, that's not quite the end of the story. So the new IIAs, the ones I looked at in 2019, included specific reactions to the Eli Lilly and Philip Morris disputes. They narrowed the scope for complaining about indirect expropriations affecting health, so except in rare circumstances, or eliminate regulatory expropriations entirely and cover only direct expropriations for the government. Some now emphasize regulatory autonomy to protect health. And some also clarify what constitutes a denial of justice. You can see at the bottom of this slide also that in this Australia-Uruguay agreement, an investor's expectations cannot alone constitute a breach of an investment agreement. So do these do enough? I remain concerned. There are many terms in these provisions that still require interpretation. Some talk about severe health concerns or rare circumstances, or allow states to take measures sensitive to or necessary to protecting public health. These terms probably aren't self-judging, and they could give rise to ISDS cases. In the USMCA, which replaced NAFTA, Canada largely withdrew from ISDS with the United States. And intra-EU IIAs are being terminated altogether or have been terminated already. My colleague Rob House has suggested that more states ought to do that. He believes that investment protection really hasn't done all that much to encourage foreign investment. And his view is that investors would be at least as well off with a robust insurance market. Personally, I don't know enough about the world of investment or the availability of insurance to endorse that view, but my analysis suggests that at least states should think hard about exposing IP assets to this protection. IP is more intrusive into a country's health, culture, economic, social order than the investment assets that are typically covered by these agreements and are subject to dispute resolution. Buildings, oil wells, access roads, ownership of an enterprise, or if IP remains a covered asset, states should clarify the relationship between IIA protection and TRIPS, not just in that one provision that we saw, and also the relationship between IIAs and the actions that other organizations might take when they impinge on IP, such as the WHO. So that's what I got. And thank you for listening.
That was wonderful. Thanks, Rochelle. So now is the moment for people to throw in their questions. I notice
So I can't see the participants.
Oh, okay. Can you click on the participant list?
On what? Gallery? All I see is you.
That's all you need.
That's true. That's true. John, by the way, did a wonderful lecture for my class this year. We all really loved it. So
my pleasure.
And I showed you everybody.
Yeah, it should be if you press on participants down the bottom and then attendees in the top right-hand corner.
Well, the participants, I only see you and the Faculty of Law.
Okay. Well, we do have
attendees. Now I see everybody, but I don't. Yeah, now I see more people.
Okay, so I don't think we've got any questions that have come up yet. So perhaps I'll take the chair's prerogative and ask one while we sort of wait for people to throw them in, because I'm sure quite a few people do have them. I think you covered this point, but it's just worth raising because it is an active interest of mine. You mentioned that long list of sort of self-help remedies that states could use, such as compulsory licenses and Crown or government use. And at least as they're implemented in the UK, they involve, well, they have to be compliant with TRIPS, so they would involve adequate remuneration. Would that mean that, supposing they are compliant with TRIPS and it is adequate, then an investor wouldn't be able to bring a dispute because they would have been adequately remunerated according to TRIPS at least?
Well, I mean, so that's one of the questions is, yeah, I mean, here government use is much more restricted here, but yeah, remuneration is required, fair. I can't remember what the term is in US law, but what the US government considers fair remuneration or what the UK government considers fair remuneration might not be what's considered fair remuneration under the TRIPS agreement. And what the TRIPS agreement people think is fair remuneration might not be what's considered fair under the IIA. So that's why all of these things, I mean, there is this huge amount of fragmentation amongst all of the different things that protect IP. I mean, in the United States, it's federal law, sometimes there's state law, there's national law, there's international law, and there's the TRIPS agreement. There are post-TRIPS agreements as well. So there are these free trade agreements that include protection both for IP and also investment protection. And then there are these freestanding bilateral investment treaties. And that's why God or Marty Koskemieni invented the fragmentation report as a way to think about how you could bring at least the international part of this together And I think that's what Henning and Federica tried to do in that South Center report. It's just, there's no way of knowing whether a panel would agree with any of that. And we already know that the WTO doesn't fully agree with Koskinen-Enya's view. I mean, it does not think that any two members of the WTO entering into a separate agreement necessarily are bound in their new agreement by what the WTO agreement says. So.
Okay, yeah. I suppose it's just not a lot of clarity, isn't it?
Yeah, and just one more thing on compensation. So the WHO actually has a document on how to determine fair compensation for pharmaceuticals. So first of all, they have more than one method, but how that figures into any of this other stuff, I don't know either, and I don't know if there've been any disputes that have ever done that. But I will also say that one of my colleagues, Richard Epstein, who is, sort of famous University of Chicago libertarian person, even though he teaches at NYU now, and he thinks fair compensation is market rate compensation, what you could get on the market. And, that would be the end of being able to give COVID vaccines to anybody, because what's the market value of something that saves your life?
Well, yeah, that's right. And that would be one of the difficulties with compulsory licensing and crown use, because one of the ideas to enforce them would be because the market is too high.
Yeah, exactly. I mean, that's why it seems to me he's just got to be wrong. I mean, why do we have these provisions in there if all it's going to be is the market rate? But
well, that's right. At least we have some comments in obiter from judgments here in which they've actually said that, one of the ideas with crown use and compulsory licensing is when they do exercise their monopoly right to charge an outrageous price. And then there's actually tests, albeit untested themselves, tests that are untested about what is an unreasonable price.
Yeah.
But we've had a couple of questions now.
Yeah. I'm just going to move away for 1 second. It's freezing cold in my office, so I've had the heater on, but the heater starts to make noise when it gets too hot. So I just want to turn it off.
Okay. So the first question, I'll take them in order, comes from Henning, perhaps not surprisingly. He says, "Hi, Rochelle. Thanks for..."
Yeah. I wish I could see people. I don't know if you can make...
Actually, if you'd like, I can actually promote people to talk. So Henning, if you do have a chance and you'd prefer to talk tonight, then send me a direct message or just out to the group. But if you're, I don't know, he might be out for a walk and listening to you at the same time. So perhaps it's not the best moment for that either. But how about we'll progress with this question. Hi, Rochelle, thanks a lot for a great paper. I got one question on the idea of police powers and who decides on the issues of public policy, proportionality, etc. What might be good concepts of allocating responsibility / decision-making powers between the host state and a tribunal? Should this primarily be deferential, e.g. akin to the approach in Australia, PP on unjustifiability, and if so, what standard of protection is left? Can you pull up this question? It should be in the Q&A below with a little...
What's PP and unjustifiability?
You've got me, actually. Henning said that he's happy to talk, so perhaps...
Oh, okay.
Here, we'll test out the technology here. There you go. So I've invited him over and I think it's activating now.
Yeah, can you hear me?
I can, yeah.
Okay, well, good to see you, Rochelle, and good to see John. So yeah, PP was just plain packaging. And so what I always struggle is with this sort of finding this balance on the one hand, where you want to leave decisions on public policy to the states, the host states, but you do want to retain some degree of protection for, be it the investment assets, the intellectual property, whatever it may be, right? And then, especially if you don't have a democratically elected or supported arbitration tribunal court mechanism, as we don't really have in international law, I would say, then the legitimacy of a tribunal deciding these matters becomes even more sort of difficult to argue for. So I'm just wondering, what could be good concepts to use here to balance this idea of leaving some degree of protection available to be adjudicated, I guess, internationally, but leaving these core decisions on public policies, even if they impact on IP, with the host state. So unjustifiability was just the concept in Article 20 TRIPS, of course, as you know, which the panel and the appellate body in the plain packaging dispute looked into. And I thought they found it quite, well, useful way to say this is not really, for example, requiring strict necessity. You don't have to show that you're using the least IP interfering, trademark interfering measure. It's up to you to decide what options are on the table and which one you go for. So that's a kind of a context I'm putting out there, and I'd be just interested to hear your views on what might be a good balancing here in that whole area. Thanks.
Yeah, so it's a great question, and in a way it goes to the heart of this question of whether we should have investment protection for IP, which has such close cultural and health and impact. I think the Uruguay panel was pretty deferential to Uruguay. But it also kept saying things like Uruguay doesn't have a lot of resources, so what can we expect them to be able to prove? They said, well, they relied mostly on the Framework Convention on Tobacco Control, and therefore we're going to allow them some deference because an international organization with real expertise in these matters has actually thought about that. But they didn't seem to act like if you didn't have a WTO determination or you were a richer country and you're able to do a lot more, that you wouldn't actually have to prove a lot more. And if you look at the WTO decision on plain packaging, hundreds and hundreds and hundreds of pages of what Australia knew and when Australia knew it, and how they should have acted, and what kinds of, how to think about the things that they did in the context of other ways in which they were already dealing with the costs of people getting cancer from tobacco. And I didn't think they were terribly deferential at all. And those panels are not democratically elected either. I mean, what we have to say about sovereignty is that there was a sovereign choice to enter the WTO and to enter that agreement, and a sovereign choice to offer IIA protection. And once that sovereign choice is made, the panels can do what we think the IIA agreement allows them to do, which seems to be to decide all of these issues. I think that wasn't a good choice for governments to make. And I think that maybe they should be pulling out of IIAs or limiting them in the way that we're now seeing recent IIAs do. But, to the extent that the idea of, put it this way, why do we have the IIA in the first place? We have the IIA because we think that the host state is not going to treat investors fairly, that the host state is going to expropriate the oil well after it's built and take all of the oil, or expropriate the IP, I guess, and take it. So we don't trust their courts, and we don't trust their government system either. And that's why we have this protection for non-discrimination, fair and equitable treatment, and direct expropriation. Well, as soon as you think that that's the problem, that the host states aren't trustworthy and that they're not going to give a fair shake to foreign investors, then a lot of deference to the state doesn't always make too much sense. I mean, I think we in IP think that this is worrisome because IP, as I said, so directly affects social welfare that it just seems wrong that, Gary Bourne, who was an arbitrator in both of these cases and with whom I clerked, and who married a princess, that he should be deciding these cases for the populations of the rest of the world. I don't feel quite the same way about, taking tires from Bridgestone Firestone or taking an oil well. I mean, they don't affect the health of the entire country in the same way that this does. But, as long as you have a trans-substantive investment agreement, I don't know. I mean, maybe you can say certain certain assets are going to be treated a certain way, and we're going to have more deference to the state, and certain ones will be treated another way. But I don't know. I mean, maybe there are investment agreements that do that, but I don't know that arbitrators are going to do that.
Henning, I see you just typed in, can I quickly reply? Did you want to reply to what Rochelle just said then?
Yeah, if I can. I mean, yeah, very good points, Rochelle. So I think, yes, like taking IP out would probably be a good, would be one really good way to deal with this, right? It would probably lead to situations where investors simply try to argue on the basis of other assets. And maybe Alex, who I've seen has also typed a question in here, might be able to add on that particular point, because I could, based on his work on trade secrets and investment protection, imagine situations where you're not formally asking for, say, for example, trade secret protection in the name of trade secret as an IP asset, but where you're simply arguing that the host state has somehow mistreated information you've provided confidentially, and that you try to get ways around it in light of the sort of more comprehensive or complex investments you've made in a particular country. The point about sort of, you could also tackle it on the side of, well, having some degree of, a review with regard to the public interest at issue. And once that sort of review has concluded that there is a genuine public health case, and it's not just sort of, about tires and whatever, then there is a significant degree of deference. Because this whole argument about sovereignty, I find always a bit difficult to necessarily convince me in all aspects, because clearly, yes, you have agreed to something, but you've agreed to whatever is in the agreement. You don't necessarily have also agreed that all the things in the agreement will be defined in all detail by an entity which isn't sort of necessarily going to be, or is not necessarily meant to be, the last arbiter of all of these things. And I think there it comes into this question about how much do you want these open contracts, because that's, I guess, what they are, right? Open contracts to be decided later by the parties implementing the contract or by an arbiter, and maybe we need some more clarity on that, right? So the sort of decision-making powers of both WTO panels as much as tribunals.
Yeah. So So a couple of one. I know you're right about the assets. That if you can't go after the IP, then you go after the factory which the IP is located. But still, I think that's less intrusive into the state's interests than going after the IP, because you still could use it, in a different factory, for example. I mean, you could still make the vaccine in another factory. That's probably more what's happening than trying to seize the assets of the factory in which Pfizer is making the vaccine, for example. I'd like to think that you're right, except when you look at these post-Lilly, post-Philip Morris agreements, you see that they actually are trying to reduce the flexibility that arbitrators have, and they're trying to say more about what is it that they can't do. So, except in rare circumstances, you can't look at regulatory actions about public health, or the one that says you have to interpret the agreement in a manner that's sensitive to health. So they are trying to tell the arbitrators that there's a certain amount of deference that needs to be given. So, I mean, they are trying to do that, but whether the arbitrators are listening or not is a different story. So, I think the other part of the problem is the one that you touched at the end is, who are these arbitrators and what's regulating them? And maybe we ought to have some kind of review of an arbitration. So, I mean, one thing, one big difference between the WTO and ISDS is in the WTO, you can go up to the appellate body. Well, if we had an appellate body, you can go up to the appellate body. So maybe someday we'll have one again. But in arbitration, under the New York Convention, these arbitral awards are directly enforceable, except under, extraordinary things like you never got notice of the award or the arbitrator was on the take. So there, and the arbitrators can do things like they can be the arbitrator in one case and they can be counsel in another case. And the two cases can be connected enough so that the arbitration decision in the one case will be very useful in the case in which the arbitrator is counsel. So UNCITRAL is trying to create new rules to somewhat control these arbitrators. The EU agreements now, are trying to figure out some way of having an appellate decision, or maybe even some kind of appellate body that would hear appeals from arbitration, more than just arbitration under one arbitration agreement. So arbitrations under many different agreements, and maybe could start developing the kind of law that you'd like to see, where we do have some, actual rules about how much deference is given, where deference is given, what a country has to do in order to earn that deference. Having rules like that within the arbitration space, I think would be incredibly useful. But we don't have it right now. We just have these arbitrators who are making their money off being arbitrators, and that leads them to want to write decisions that will lead them to be appointed as arbitrators another time. And it's not that part of it is not it's not so much a democratic deficit, it's a fairness deficit that I think may be part of what you're reacting to.
That's a really interesting discussion. And to an extent, I'd like to continue it, but we also have another question and I'm mindful of time. Yeah. So Alex has posted saying, thank you for the presentation. When a company says they won't prosecute their IP rights, would that prevent them from pursuing ISDS?
Yeah, I suppose it would if they say that they won't do it.
A waiver of a type, I guess.
Yeah. Part of the problem, Henny, if I have had this discussion too, just a little bit of a different question. If the state waives TRIPS obligations, and the ISDS panel decides, well, then there's no ISDS claim, could the investor sue their own state for having waived their claims? But I imagine investors can waive their claims. I don't know, Henning, maybe you have some ideas the answer to that question.
And I suppose there could be a process for a withdrawal of the waiver as well. I know people have talked about them with various patent pledges and things like that. The idea that, say, Tesla has pledged a lot of its patents for batteries. Yeah. But at any stage they could withdraw that pledge, perhaps with some form of notice.
Yeah, and some of the pledges themselves are limited in time, and it's not clear how you think about those limitations. So, for example, let's say something is pledged that allowed, something about, some patent on lipid technology, and that allowed Pfizer to develop the mRNA vaccine. Well, the mRNA vaccine is going to continue to be sold, and it's still going to continue to use that that lipid technology, or having known it is what produced the mRNA vaccine. When the pledge is over, then what happens? So the pledge is for 5 years. We're at year 6.
Yeah.
Can Pfizer still use it, or do they now have to enter some kind of an agreement? If they have to enter into an agreement with the original patentee, they're really over a barrel, because they now have all this investment in using that technology, and it's not going to be so easy for them to move to a different technology. So, waiving, I guess, could lead to an investment dispute over exactly what the waiver actually meant, and a claim that the waiver was misinterpreted and denied fair and equitable treatment, or was a misappropriation, expropriation rather.
Yeah, I think that makes a lot of sense. And as you sort of pointed out as well, some of these waivers or pledges can be very strategic in the sense that they drum up future business.
Yeah, I mean, just look at the standard essential patent cases. You put your patent into into the package, and then suddenly what sounds like reasonable compensation suddenly there's a few zeros at the end of what's considered reasonable, and everybody is now invested in using that exact technology and can't get out of it so quickly. So yeah, so they are very strategic.
Yeah, quite crafty there.
Yeah.
So I noticed that we've come up on 6:30 here, which must be 1:30 for you. So
Yeah.
I'm inclined to draw this to a close. Of course, I deeply appreciate you coming online, even at short notice, Rochelle, tonight.
Yeah, sorry, I misspeak. I even looked, and I guess I'm not good calculating. Anyway, hello to everybody. Lionel, I see you said hello to me, so hello to you and Claire.
Yeah. We'll have to get you back over to Cambridge sometime, particularly for May. It is
Henning.
very...
Someday there will be a May, whatever it's called, party at King's.
We would always be happy to have you back here anytime. So look forward to that, Rochelle, and thanks a lot again.
Yeah. Thanks so much for the talk, and I'd like to thank everyone else for tuning in. I think we'll be around next week with another presentation, and so until then, hope you all have a good week.
Bye-bye.
Bye.